Alrighty, this We the People News. One more time at it. Educational purposes only, not attorney not giving legal advice. Alright? Arm yourself with knowledge. Use that Second Amendment. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Alright? And again, go to the 10th Amendment Center. Check out their stuff. And Chris and Hall, go look her up as well. Okay? If you get with both these people, you're going to learn a lot. Okay? And let's proceed forward, shall we?
Of hours after the live stream is done, over at 10thamendmentcenter.com/path to liberty. It's all spelled out, 10thamendmentcenter.com/path to liberty. Now let's get back to Virginia, where Edmund Randolph, a real heavyweight there, first Attorney General, he was a framer in the Philadelphia Convention, a lead advocate for ratification in the Virginia Ratifying Convention in 1788. Now, he took the lead in the opposition over the Ninth Amendment. The Ninth Amendment was the issue. He thought that this new streamlined language in the Ninth was dangerously vague, and it would no longer operate as a provision against extending the powers of Congress by their own authority. He thought there would be construction to expand the power by kind of this implied idea that we were warned about early on. And because of this opposition, he got enough people on board that the Virginia House voted to delay the debate consideration of the Ninth and 10th Amendment for 2 full years. And this effectively stalled the entire ratification process. And as Hardin Brumley wrote to James Madison, he warned that rejecting those 2 amendments would likely bring the whole into hazard again. They knew that unless this was resolved, it was over. They were not going to get this Bill of Rights, and then you'd have all kinds of other problems. Now, as Kurt Lash points out, Virginia was really alone on this point in opposition to the Ninth Amendment. No one else did this. He said no other state legislature complained about the final language of the Ninth. All of these states, he wrote, knew that Madison's original version of the Ninth expressly limited federal power because his proposals had been widely published in newspapers across the country. Only in Virginia were concerns raised about the final version of the Ninth, but it was Virginia. And if Virginia was saying no, well, that was going to cause a problem probably in other places, or just hold the whole thing up. And, well, it was going to be a domino effect. They were very, very concerned about that. Again, those concerns in Virginia, they delayed ratification for 2 full years. So enter James Madison. It's early 1791, and there's a debate raging in Congress over Alexander Hamilton's proposal for a legislation for a bill to establish a national bank. So on February 2nd, 1791, just over 10 months before the Bill of Rights were eventually ratified, Madison gave another speech in Congress, but began his argument by laying out a fundamental rule about the Constitution of limited and delegated powers. He said, an interpretation that destroys the very characteristic of the government cannot be just. Madison described it in Federalist 45 some years earlier as a document of powers that are few and defined. Everything else was reserved to the states or to the people. And so if you were to interpret this in a way that ran counter to that explanation that everyone decided or agreed upon, that's how they ratified the document, well, this is unjust. It's wrong. He then reminded everyone about the deal to ratify, that this was going to be a system of federal power that would be strictly interpreted, few and defined powers. He said the defense against the charge founded on the want of a Bill of Rights presupposed that the powers not given were retained, and that those given were not to be extended by remote implications on any other. See how these 2 kind of rules of construction are always put together by James Madison. On any other supposition, he said, the power of Congress to abridge the freedom of the press or the rights of conscience, etc., could not have been disproved. Then he says, don't take my word for this, that we agreed that the ratification was done on this understanding. Here are some of the records from Pennsylvania, Virginia, and North Carolina to prove it. He said the explanations in the state conventions all turned on the same fundamental principle, and on the principle that the terms necessary and proper gave no additional powers to those enumerated. And there he read, this is from the notes, read sundry passages from the debates of the Pennsylvania, Virginia, and North Carolina conventions. And next up from Madison, the slam dunk. In case anyone forgot, we are putting it into writing. And then he read the pending 9th and 10th Amendments. The former.
And again, if you need to rewind back, necessary and proper did not give them more authority, right? And what's these judges doing? They're saying it's necessary, it's proper. These quirks, it's necessary for officer safety. It's proper for officer safety. So we're going to create and bypass Congress and create a doctrine, and we're going to call it law to violate people's rights. Never mind that the contractor is supposed to uphold the oath of office, to protect us.
It's guarding against a latitude of interpretation, and he said the latter as excluding every source of power not within the Constitution itself. With this explanation, James Madison expressly linked the 9th and 10th Amendment as partners to jointly protect the reserved powers and rights of the states and the people themselves. And with that, much of the remaining
Again, what is that? 9th and 10th. They are partners. So when one just throws the 10th Amendment and ignores the 9th, that's not proper. No pun intended. Right? So you got to use the 9th and 10th. All right? And then go to Bouvrelet Dictionary and read the 9th Amendment, but look up the words it says in there. So that way you can fully comprehend, right? Because a lot of these people read these things, but they take it as judges' opinions about them. They don't really go up and look at the words, how the original intent is.
Position in Virginia was convinced, and on December 15th, 1791, Virginia became the 11th state to approve the first 10 amendments to the Constitution, known today as the Bill of Rights. So the 9th Amendment wasn't a tool to expand federal power. It was a rule of construction meant to explain the limits of federal power. A partner to the 10th Amendment in support of both individual rights and the right to local self-government. Incredibly important stuff for the founders and the old revolutionaries. And here, in his view of the Constitution of the United States, St. George Tucker laid out how the 9th and 10th Amendments work together as a firewall against federal power. First, the 10th, he explained, was to guard against encroachments on the powers of the several states in their politic character and of the people, both in their individual and sovereign capacity. And then the 9th, about expansive constructions of power that attack or destroy your liberty and rights. To guard, he said, the people against constructive usurpations and encroachments on their rights. Put them together, the 9th and 10th Amendment, and this is what you get. He said, the sum of all which appears to be that the powers delegated to the federal government are, in all cases, to receive the most strict construction that the instrument will bear, where the rights of a state or of the people, either collectively or individually, may be drawn into question. And John Taylor of Caroline, some years later, in Construction Construed and Constitutions Vindicated, he made...
In all cases, right? So the judge is actually supposed to look at you as the individual, as one of the people as well, right? And make sure the overall view, is it taking the individual's rights away? We go back to taxes, your property tax. You have a right to own property. But if it's taxed, then you don't have a right to own property. Well, that's taking an individual rights away due to the property tax. And again, you got to be really careful with the state. So you got the state as a political union with our taxes per se, right? And then you got the individual uh, people, which is just another state, but it's just in its individual capacity as one of the people. One of the people. One of the people.
The same case that the 9th and 10th are partners for federalism. And again, he's mentioning, he references them as the 11th and 12th. The 11th Amendment, he said, prohibits a construction by which the rights retained by the people shall be denied or disparaged. And the 12th reserves to the states respectively or to the people the powers not delegated to the United States nor prohibited to the states. And Taylor continued with this: the precision of these expressions is happily contrived to defeat a construction by which the origin of the Union or the sovereignty of the states could be rendered at all doubtful. And again, for Taylor, for Madison, and for so many others, the sovereignty of the states is really about the final authority of the people of the several states. The 9th Amendment was no afterthought. It was the final lock on federal power. It doesn't expand liberty from the top down. It protects against federal attacks on liberty from the bottom up. Alongside with its partner, the 10th Amendment, it completes the firewall that was demanded by the state ratifying conventions during the ratification debates. The 9th Amendment doesn't compete with the 10th Amendment. It helps protect it, and vice versa. Together, the 9th and 10th Amendment lock in a core principle: delegated powers only. Everything else stays close to home or with the individual. Unfortunately, the government-run and government-approved education system never teaches much of this, if any of it at all. And that's a huge part of the reason why we work so hard every single day to reach and teach more and more people about these essential principles from the founders, from the old revolutionaries, about the Constitution, about liberty, how to defend both when government refuses to do so, which is, well, 24/7, 365. And nothing helps us do this work more than the financial faith and support of our members.
So, yeah, if you get a chance, also donate to them because they are doing a lot of original intent of the founding fathers bringing forth to y'all. So, of course, if you have any questions, there's that right there. Allegedly, I never called it, but people, we need to start bringing the original intent back into our system and getting these judges to start paying attention again. I got another video coming up. It's going to be really interesting, probably tomorrow night. But I'll save that for later. This is Diesel We the People News. Until next time, educate yourself so you can arm yourself with knowledge. Okay? Quit thinking outside the box, especially the grand jury. Take everything from the prosecutor's grain of salt. It is legal for them to lie to you. That's the reason why you would be willing to indict a ham sandwich. All right? Because their lies are so good. Okay? So be careful when they come up to you and go put you in a secret box where I'm not allowed to be for you to issue that writ to arrest me. And you are my protector, grand juries. You got to be sure through its